For many people, renting a property is all new and can be quite a daunting prospect. I'm here to see what's involved, what my rights are and what's expected of me regarding tenancy. Ian, as Operations Manager of Arla, you're going to take me through the process of becoming a tenant.
That's right, Nikki.
I've found this wonderful apartment. I want to rent it. What's the next stage?
The next stage is to find out the terms and conditions that the property is available on, how long it's available for, what the rent is, whether you can negotiate the rent, and what fees you're going to be expected to pay up front. Are you going to be expected to pay a holding deposit, an administration fee, referencing fees? Right,
there's a lot going on there.
A lot going on there.
What's referencing?
Referencing is where the landlord or the tenant will want to, the agent will want to check you out as being a suitable tenant. They'll look for a previous landlord's reference, possibly. They may look.
So you need to supply that as a tenant. You need to supply that to the letting agent.
Not necessarily. The agent will very often use a referencing agency who will take up all these references. They'll do a credit check on you. They'll contact your employer. So it's worthwhile mentioning to your employer that they may be being contacted. The agent will tell you the company that might be carrying out the reference for them.
But as a tenant, you might be liable for a fee for that. Is that what you're saying?
That's correct.
Right. Now, what about the length of the tenancy? How long would I expect to have the tenancy for?
Quite often, an initial period of tenancy will be 6 months. In England and Wales, you can get a tenancy for less than 6 months by mutual agreement. In the rest of the country, you're looking at a minimum of 6 months. Quite often 12 months would be a landlord's requirement as well, sometimes even, as I said, 2 or 3 years.
What about the deposit side of things? How much deposit would I have to put down?
Deposit would normally be somewhere between a month and 6 weeks. It should not normally be, under any circumstances, more than 2 months.
Okay.
The equivalent of 2 months' rent.
Right, that's quite reassuring. So once that I've moved in as a tenant, what are my responsibilities at that point to the property and the landlord?
Your first responsibility is to check the inventory that you'll have been provided with, make any comments relative to the inventory needing corrections made to it, and then to look after the property in a tenant-like manner.
So could I ask you, if I don't agree, say, with something on the inventory, what do I do then?
You should contact the landlord or the agent with your comments within as soon as it becomes apparent to you, as quickly as possible, and normally within 10 days of taking occupancy of the property.
OK, so would I have the opportunity to see the inventory before I took occupancy and before I placed a deposit?
It's possible, but it would be fairly normal nowadays that a tenant would be provided with the inventory as part of the tenancy agreement at the same time.
OK.
And they would be given time to check it.
OK, so apart from the inventory, what are the other responsibilities for me as a tenant while I'm in the property?
To look after the fabric of the property, to look after the contents of the property, and your tenancy agreement will probably also state that you're responsible for paying your utility bills, television licence. You may require to get permission from the landlord to have things like satellite television installed if that's not there as part of the package.
So there'll be quite a few variables in that.
That's right, and they should all be very clear in your tenancy agreement. Nowadays, you could expect a tenancy agreement to be 20 pages long.
So, for example, if I have a dog, would I be able to take the dog into a property?
That is something that you may or may not be able to do. Again, generally speaking, that depends on the landlord. But if it is a leasehold property, it may be against the conditions of the head lease, so you may not be able to, even if the landlord was willing.
I see, I see. Now, if I wanted to leave the property, say before the 6 months, what would happen then?
Well, you have signed a contractually binding agreement, so you are liable for all the obligations of the tenancy. Sometimes a landlord or an agent will be able to help you to get out of your tenancy by finding someone to replace you, but you will very likely be liable for costs and charges incurred in that. And again, you should be asking for those in writing so that you're quite clear what your obligations are going to be.
OK. Once the first 6 months is over, do I then sign up for another 6 months, or how does the next term work?
That's a variable. There are two options. It can either be another fixed term, which doesn't have to be 6 months. It could be whatever was mutually agreeable for an extension to a tenancy, or you may want to allow the tenancy to go what's known as periodic, and that means that the landlord has to give the tenant 2 months' notice if they wish to bring the tenancy to an end, and the tenant would, generally speaking, if the rent has been payable monthly, have to give a month's notice.
OK, so in other words, it's an indefinite tenancy, but I could say, if I want to leave any time after the first 6 months, I could give a month's notice.
That's right, to a rent due date.
So does that apply to all tenancies in all parts of the country?
It's not quite the same in every part of the country, Nikki. In England and Wales, you could have a situation where your tenancy was above a certain rent level, or the company, or the tenant rather, was a company, and that would not be what's known as an assured short-hold tenancy.
And that's the normal tenancy?
That would be the normal, that would be what we would call the default type of tenancy.
What's the other one then?
It would just be a law of contract, a non-housing act tenancy. In Scotland, you would have a different situation after the 6 months was up, because you have to have some type of a contract in place with it. It's not just as open as the statutory periodic situation in England and Wales. And there are also some drawbacks at that point in time to a company tenancy. In Scots law, it could go into what's known as tacit relocation, and that means it would extend itself automatically contractually on both sides for the same period as the original contract. OK, so that's completely dependent on the variation of the tenancies. So what you would want to do was make sure that you were using an ARLA agent who could go through the types of tenancy agreements with you in the relevant part of the country, and they would be able to explain the nuances that exist.
The subtle differences.
Subtle differences.
Yeah. So the tenancy has come to an end, from my point of view. It's agreed between myself and the landlord. How do I then go about getting my deposit back? Is that an automatic thing?
It should be, if you've kept the property clean and tidy. What should happen at the end of the tenancy, all over the country, is that the inventory should be checked. Any damages and dilapidations would be agreed, hopefully, and anything that wasn't agreed would be negotiated. At that point in time, you would then go into a different situation between Scots law and English law. In England, your tenancy deposit would be likely to be covered under tenancy deposit protection, and that would mean that it was registered with one of 3 schemes that are licensed by the government, and if there was a dispute that couldn't be resolved, then that scheme would get involved in the dispute. There is no such legislation north of the border, and in fact in Scots law the tenant's deposit is held as landlord's agent or by the landlord, and if the landlord wants to walk off with it, it is a case of a legal matter that would have to go through the courts.
So the legislation that you mentioned that applies in English law is really, it sounds as though it's to the advantage of the tenant in most cases.
It's the advantage of both sides, because it's an independent arbitration that has to be carried out, and they will look at the evidence that both sides are able to provide, and that's why the inventory at the very beginning and at the checkout point are so important, because they will state what the condition is and what damage has been done, and whether it's reasonable depending on the occupation of the property, because a landlord letting the same property to a family has to expect more damage than if you were renting it to you and I. Because of course the landlord will know who they are letting to. They should know who they're letting to. Yeah. So really it doesn't have to be a complicated process. There's legislation there to protect both parties and it could go very smoothly. Yes, absolutely. I mean, there are several pieces of legislation. There's several landlord and tenant acts. There's several housing acts, all of which control what both landlords and tenants should be doing. Great. Well, I'm looking forward to moving into my rented property then. Good luck with it. Thank you. Thank you.
So there you have it. Renting a property is straightforward and safe, provided you rent through an ARLA agent. If you want to know more or you have any questions, why not drop in and talk to an ARLA member in your area? For further details, www.arla.co.uk.